Well, welcome everyone to another in a series of our Berkeley Law alumni virtual events. I hope everyone is well. My name is Yury Kapgan. I'm class of 2001, and I head up the Los Angeles chapter of the Berkeley Law Alumni Association. I'd encourage everyone to attend some of our upcoming events. You can see some of those alumni events that we have planned in the chat. It's nice to see a lot of familiar faces here virtually. I look forward to seeing many of you again in person when in-person events resume. Today's talk by Dean Erwin Chemerinsky is entitled The Path Forward for American Democracy, and he's also going to provide an update on the law school for us. If you have any questions during the talk, please put them in the chat to the host, Doreen, and we'll try to answer them after the talk. With that, let me introduce the man who really needs no introduction, but I'll mention very briefly anyway. For anyone who may not be familiar somehow, Dean Erwin Chemerinsky joined the Berkeley Law faculty in 2017. Before that, he was the founding dean of and professor of law at UC Irvine. Books and over 200 law review articles. In short, he's truly a force of nature. So Dean, let me turn it over to you.
Thank you, Yury, for the kind introduction. Thank you for all you do for the LA chapter and also for all you do for Berkeley Law. And welcome to everybody tonight. Thank you for coming. I was asked to do two things. One is to give a quick state of the law school address. And the second is spend most of my time talking about the path forward for American democracy. In terms of the law school, as I think you know, all of our classes this year were online. Classes ended yesterday. The students are in their study period right now, and exams will start on Monday. On the one hand, there's a real sense of we did it. We were able to have all of our classes taught remotely and provide excellent instruction. I sent a note to the faculty yesterday morning, congratulating them on this milestone. And I said, in the average semester at Berkeley, the median teaching evaluation for non-seminars is 6.01. The median teaching evaluation in the fall semester was 6.10. I think it reflects the tremendous hard work of the faculty and the patience and perseverance of our students. But I'm not going to minimize the difficulties of being online. I taught a large class in a seminar each semester, and it's just different teaching over Zoom or being a student over Zoom than it is when we're all in the classroom together. There's certainly a loss of community. I think everyone is frustrated having been apart for the entire year. And I think many in our community have suffered real hardships this year. But we're going forward. Commencement will be on May 21st. Alas, it too will be online. We have a great commencement speaker, Brian Stevenson, and this chancellor had said that all of the commencements at Berkeley this year will be done remotely. Just a few topics that might be of interest to you. Applications for next year, the class of 2024. They are phenomenal. Last year, we received about 5,500 applications for 320 anticipated slots. This year, we received well over 8,000 applications for 320 slots. Nationally, applications are up under 20%. Ours were up over 50%. I hope this reflects the strong perception of Berkeley law across the country. The entering class for next fall looks like it's going to be terrific by every measure. The median LSATs and GPAs are likely up over this year. Our diversity numbers are going to continue to increase. And it really is a class that looks to be outstanding in every way. In fact, the only worry now is that we accepted too many based on past projections. We might end up with a larger class than we want. And in some senses, it's a nice problem to have. And in some senses, it's really difficult because we don't have the classrooms and the space for it. But we will see what happens. A second topic that may be of interest to you concerns faculty appointments. So far, since 2017, hired 19 new faculty members. I don't think there's any law school in the country that's hired 19 new faculty members. And they're really outstanding. They come both from other law schools and those starting their teaching careers at Berkeley. A year ago, we had 9 new hires in a year. 4 were lateral hires and 5 were entry level. Of the 4 lateral hires, one was Kiara Bridges, who came from Boston University, teaches family law and criminal law. One was Jonah Galbach, teaches University of Pennsylvania, teaches law and economics and civil procedure. A third was David Graywell, who was a tenured professor at Yale Law School, teaches international trade and the jurisprudence social policy program. And the final was Orrin Kerr from the University of Southern California, teaches criminal law and criminal procedure. We have 2 new hires who will begin with us on July 1st. So that's in addition to the 19 that I mentioned. Jennifer Chacon, who's a professor at UCLA Law School, who focuses on immigration law and constitutional law. And Jonathan Glader, also from UCLA Law School, who focuses on criminal law and also education law. We still have a number of slots to fill in the next few years. And I think it's been wonderful for the morale in the law school and the faculty to see terrific people with offers at other top schools choosing to come to Berkeley. A third topic that might be of interest to you concerns the job market for our graduates. And again, I have great news to report with regard to that. For the class of 2019, 98% were fully employed JD required jobs 10 months after graduation. And that's about as close to full employment for a graduating class you can get, because there's always some students who are getting MBAs or PhDs. They don't count as employed, or there's always a student or two who's taking time off after law school for family reasons. I was very worried what it would be for the class of 2020, but 10 months after graduation, 95% were employed in full-time JD required jobs. And that's a bit artificially low. There were 4 students who have full-time jobs, but just hadn't started by the March 1st reporting deadline. The bar exam being later, pushed their start dates a bit later. So we're over 96%, which under all of the circumstances looks great. Thanks to all of you, firms are taking Berkeley Law graduates. Just wonderful for the school to be able to have our students placed in such terrific places. In terms of summer employment for the rising 2Ls, it looks great. Again, it's going to approach 100% of the rising 2Ls having jobs. If you wonder what our graduates are doing now, of the class of 2019 and 2020, about 60% are going to law firms over 100 lawyers. About 20% are going to government or public interest jobs. About 15% are doing judicial clerkships right after law school, though the number that do judicial clerkships is a lot larger than that because it's become increasingly common for people to work for a year or two and then clerk. And about 5% are working at firms smaller than 100 lawyers or going directly in-house or something else. The only major cloud on the horizon for the law school this year has been financial. It's been a really tough financial year for the law school. I'm sure you know, we're very dependent on our LLM program. And the LLM program is all foreign students who come for a year to Berkeley. Well, because of visa restrictions on account of COVID, that program was greatly reduced. It was cut by more than half from last year to this year. In dollar terms, we lost $9 million of revenue that we had last year from LLM students that we don't this year. The campus, which we don't get that much money from, cut us by $2.5 million. A year ago, about 7% of our budget net came from the state. They cut that by $2.5 million. We don't get much from the Office of the President. A year ago, we got $1.8 million. They cut that this year by $500,000 to $1.3 million. You put it together, we lost $12 million in revenue this year that we had a year ago. I was determined we would absorb this without laying off staff, without in any way impinging on the educational program, and we succeeded. We've not laid off staff. We have not cut a single class or lecture. In part, we did this by the money that we could save by not having to pay for travel. the money we save by not paying for events in the building. We've left some non-essential positions unfilled. We still ended up with a deficit this year. It'll be under $3 million, but we do have cash reserves and we can absorb it from the cash reserves. But it has been a tough financial year for us, for the campus, for all of higher education. So overall, the report is strong. The last thing I'd mention with regard to my state of the law school concerns the rankings of the law school. I always feel great trepidation before the rankings come out. They're so arbitrary. Is an example of that. What really separates schools in the 6 to 10 range where we're located is per student expenditures. But being a large public law school with the least tuition of any of the top 10 schools hurts us in per student expenditures relative to those schools. And then to make it even more capricious, US News discounts our per student expenditures by 25% based on a cost of living adjustment and adds 10% to Virginia's. Well, if they just refrained from the cost of living adjustment, we would have ranked 8th this year rather than 9. We were ranked 9 overall, as I said. In terms of specialty rankings, they were stunning. We're number 1, again, and some of these are ties, in intellectual property, number 1 in environmental law, number 2 in criminal law and criminal procedure, number 3 in business law, number 6 in constitutional law, number 6 also with regard to the international law program, number 7 with regard to contracts and commercial law, number 9 with regard to the clinical program. If you take those categories and compare the state of Virginia, the school ranked right ahead of us. We were ahead of Virginia in all but one category where we're tied with them. It really does reflect the tremendous quality of Berkeley Law School. I'll be glad to answer any questions you have about the law school, but let me move now to the topic that I was given, and that's to focus on the path forward for American democracy. I think that all of us saw in late 2020 and early 2021 that American democracy is more fragile than we could have ever imagined. I spent a great deal of time over the last 6 months thinking about what are the dangers to American democracy and what is the path forward. In fact, I just signed a contract to write a book for Norton. It's not due till 2022 and it won't be out till 2023 on this topic. So in some senses, I'm sharing you my preliminary thoughts on it and would love to come back to you when the book is done and share with you what I've come to. I think that there's so much to talk about with regard to what we saw in late 2020 and early 2021 with regard to the threat to American democracy. To be blunt, we saw an attempt by the President of the United States, Donald Trump, and his supporters to overthrow the outcome of the election. Joe Biden won the popular vote by 7 million votes. Joe Biden clearly won in the Electoral College. The challenges of voter fraud were rejected by court after court across the country. And yet, still you find that opinion polls show that a significant number of Republican voters believe that the election was stolen. In the end, there's a sense that we can be sanguine because, after all, the guardrails of democracy did hold. Think about it. There were 33 lawsuits brought by Donald Trump and his supporters challenging the results in particular states. In 32 of 33 cases, the courts ruled against Donald Trump. And the 33rd, was a relatively minor issue about how close poll watchers could stand while watching the counting of absentee ballots. Didn't matter whether the judges were appointed by Democratic presidents or Republican presidents. Didn't matter if they were state or federal judges. All of the judges concluded that there was no evidence of fraud. If I was to commend one particular opinion, the decision by the Third Circuit Judge, Stephen Vivos. He was appointed by President Trump to the Third Circuit. He's quite conservative. He said there was absolutely no evidence of fraud in the counting of the votes in Pennsylvania. He said he would have thought that if there'd be a lawsuit alleging fraud, there would certainly be some evidence of it. What though if the guardrails of democracy hadn't held? What if election officials in states like Michigan and Georgia had caved to pressure from the President of the United States, notwithstanding the popular vote in those states, certified the elections for Donald Trump? What if state legislatures in Pennsylvania or Michigan had said that they were going to exercise their power under the Constitution to award their state's electoral votes to Donald Trump? What if the courts had not stood up to Trump? What if Trump had gotten his wish that Republican judges, especially Republican voting justice on the Supreme Court, would have given him the election? What if Mike Pence on January 6th had said that he wasn't going to accept the results that were presented from states such as Michigan, Georgia, Pennsylvania, Arizona, but was going to instead accept alternate delegates and made Donald Trump president? None of those things are fanciful. Any of them could have easily happened, and we would have a very different situation today. It's not hyperbole to say, at that point, we no longer would have been a democracy. Well, what I want to think about and talk about a little bit today is what are the underlying threats to democracy? And then what's the path forward to solve this? Think about the Constitution and the institutions that it creates. And let's go through them and analyze them from the perspective of, are they democratic? No matter how you want to define democracy, do they fit the definition that we would have in mind of that? Start with the Electoral College. If 49,921 votes had come out differently in Arizona, Georgia, and Wisconsin, Donald Trump would be president of the United States despite losing the election by 7 million votes. Twice in this century, in 2000 and 2016, the loser of the popular vote became the president of the United States. That almost happened in 2004. Had John Kerry won Ohio, he would have been president despite losing the popular vote. States with just 22% of the population can conceivably choose the president. The Electoral College was based on distrust of the people. Alexander Hamilton in Federalist Papers made clear that he favored the Electoral College because he wanted an elite group to choose the president. But the Electoral College was also based on protecting the institution of slavery. If there was popular vote for the president, slaves would not have been able to vote. So Southern states would not have had any influence based on their slave population in choosing the president of the United States. The Constitution says that in allocating seats in the House of Representatives, slaves would count as the notorious 3/5 of a person. Seats in the Electoral College are allocated by adding a state's senators and representatives. Well, states with slave populations then got benefit, at least of 3/5 of that number, which is a lot more than none. This is not just in hindsight. At the Constitutional Convention in Philadelphia, Hugh Williamson from North Carolina defended the Electoral College as a basis for protecting states with slave populations. None other than James Madison did too. Well, let's talk about another institution created by the Constitution, the Senate of the United States. The Senate is inherently anti-democratic. What you have is every state gets 2 senators, regardless of its size. In 1787, Virginia, the then largest, most populous state, had 12 times the population of Delaware. In 2010, we don't yet have the 2020, or at least I have not seen the 2020 census status, California had 65 times the population of Wyoming. Well, I'll put this to you another way. The 50 Democratic senators represent 42 million more people right now than the 50 Republican senators. The Senate, as I say, has always been anti-democratic, but it's become much worse because of the filibuster. The filibuster essentially says, except for judicial nominations and cabinet nominations and certain budget matters, all other legislation takes 60 votes. Now, for much of American history, there was no way to limit debate in the Senate. And then a rule was created that allowed for an end of debate in the Senate, called cloture. The Senate, though, allowed a filibuster. And if you've seen the movie Mr. Smith Goes to Washington, and if you haven't seen it, I commend it to you, it involved Jimmy Stewart, an idealistic senator, filibustering by holding the podium until he literally collapsed. That's how the filibuster used to be. A senator would have to hold the podium until he could do so no longer, or pass the baton to someone else. And everyone would have to be there the whole time because they didn't know when the cloture vote would be taken. In 1975, the Senate changed this rule. So now the Senate can do its other business while a filibuster is going on. All a senator has to say is, I want a filibuster, and then it'll take 60 votes to end that filibuster, or the matter will never come for a vote. This allows senators representing a minority of the population to thwart the will of the majority. Well, the third institution created by the Constitution is the House of Representatives. It was meant to be the democratic institution provided for in the Constitution. But because of the growth of partisan gerrymandering, that's not happening. Partisan gerrymandering, of course, is the political party that controls the legislature, draws election districts to maximize the seats for that party. It's where, say, a Democratic-controlled state legislature draws legislative districts for the state to favor Democrats, or a Republican legislature draws congressional districts to favor Republicans. In California, it's not done this way because we're one of a handful of states that has an independent districting commission to draw the lines. Partisan gerrymandering has existed since early in American history. It takes its name from a governor of Massachusetts, Elbridge Gerry, early in the history of the United States. But what's changed is, because of sophisticated computer programs, partisan gerrymandering go on with more precision than ever before. Consider the state of North Carolina. North Carolina is basically a purple state. It went for Obama in 2008, went for Romney in 2012, went for Trump in 2016 and in 2020, but always by very close margins. Republicans gained control of both houses of the North Carolina legislature and then said they were going to engage in redistricting. And they said their objective was to give Republicans control of 10 of 13 House seats from North Carolina. The memo, which is public, said if they could, they would get more than 10 seats, but they want at least 10. They drew up 3,000 different maps as ways of drawing election districts. They chose the map that maximized the likelihood of Republicans controlling 10 of 13 seats. In 2016 and in 2018, Republicans and Democrats got almost exactly the same number of seats, same number of votes for seats in the House of Representatives in North Carolina. But Republicans won 10 of 13 seats because of partisan gerrymandering. A lawsuit was brought challenging partisan gerrymandering. Rucho versus Common Cause comes from North Carolina and challenging just what I described to you. And a 3-judge federal court found that the partisan gerrymandering in North Carolina violated equal protection. The United States Supreme Court 2 years ago reversed in a 5-4 decision. The Supreme Court split along ideological lines. The majority was Chief Justice Roberts, Justice Thomas, Alito, Gorsuch, and Kavanaugh, held that challenges to partisan gerrymandering are non-justiciable political questions. That is, federal courts can't hear challenges to partisan gerrymandering. Justice Kagan wrote a powerful dissent. She said, in a democracy, it's supposed to be voters who choose their elected officials. Partisan gerrymandering means it's the elected officials choosing their voters. But because of Rucho versus Common Cause, except in states where there's independent districting commissions, legislatures will be able to engage in partisan gerrymandering with impunity. Well, the Constitution creates a fifth institution as well, the United States Supreme Court. The Supreme Court was meant to be anti-democratic. Its members are chosen by the president, confirmed by the Senate. They serve for life. But for many reasons, we've seen the Supreme Court become quite unbalanced ideologically. Since 1960, we've had 32 years with Republican presidents and a little over 28 years with Democratic presidents. In 2024, we'll reach 32 years with Democratic presidents and 32 years with Republican presidents over a 64-year period, which is remarkable. But since 1960, Republicans have appointed 15 justices to the Supreme Court, and Democratic presidents have appointed only 8 justices to the Supreme Court. And the problems with democracy that I mentioned earlier manifest themselves here too. Take Brett Kavanaugh. He was appointed by a president who lost the popular vote and confirmed by senators who represent just 44% of the population in the United States. Also, the anti-democratic nature of the court is increased by life expectancy of the justices. When the Constitution was written in 1787, average life expectancy was 36 years old. But think now of Clarence Thomas, or say Elena Kagan. Thomas was 43 years old when he's confirmed for the court in 1991. If he remains on the court until he's 90 years old, the age when Justice Stevens retired, he'll be a justice for 47 years. So this doesn't sound partisan. Elena Kagan was 50 when she was confirmed. If she stays till she's 90, she'll be a justice for 40 years. To me, that very much heightens the anti-democratic nature of the court. Or consider Justice Amy Coney Barrett, the newest member. She was 48 years old when she was confirmed. If she stays until she's 87, the age which Justice Ginsburg died, Barrett will be a Supreme Court justice until the year 2059. So those are the institutions of government that the court creates, that the Constitution creates, and trying to describe what I see as the threat to democracy for each of them. But there's another threat to democracy. It is very much tied with race and with the suppression of the vote. This isn't structural in the same way in the Constitution, but it's real. What unites the things that I talked about is they all can be traced back to the Constitution itself. That's certainly true of race. This is a document that institutionalized slavery. Consider some statistics in terms of race and the threat to democracy. Enormous inequalities exist. 24% of African Americans and 21% of Latinos live below the poverty line, compared with only 9% of whites. 40% of African American children are born in and live in poverty, compared to 14% of white children. The incarceration rate among African American men is more than 3,000 per 100,000 citizens, 4 times the national average, and 6 times among white men. An African American male born in 2001 has a 32% chance of serving time in prison at some point in his life, while a white male born at the same time would have a 6% chance of being sent to prison. I could go on with the statistics, all of which are the legacy of racism. And this manifests itself here with regard to democracy. Think of the laws that have been passed in states like Georgia, Arkansas, that are clearly designed to disenfranchise minority voters, to make it harder for them to go to the polls. What's the path forward? I'm by nature an optimist. What can we do? Well, for some what I discussed, I don't know. I would eliminate the Electoral College, but that would take 2/3 of both houses of Congress and then approval by 3/4 of the states. There's no way that the states that benefit from the Electoral College will ever vote to eliminate it. I would change the Senate so it has proportionate representation. I wouldn't keep 2 senators from each state. Or at the very least, I'd admit more states like DC and Puerto Rican statehood. but I don't foresee that happening. I want to eliminate the filibuster, or at least return to the old talking filibuster. I would eliminate partisan gerrymandering. And if the Supreme Court won't, then states should, by initiatives or under their constitution. I would impose mandatory term limits for Supreme Court justices. I would have 18-year non-renewable terms. All of these are the kinds of things that need to be contemplated in considering the path forward. But most of all, what I would want Congress to do is pass a bill that strengthens voting rights. Such a bill is introduced into and passed the House and is pending in the Senate. It would do many things. It would create national standards for absentee ballots to make it easier for people to vote absentee. It would eliminate partisan gerrymandering for seats in the United States House of Representatives, but couldn't touch it for state and local governments. It would reenact crucial provisions of the Voting Rights Act that the Supreme Court declared unconstitutional in Shelby County versus Holder. These are all things that can be done, but the catch is, to get them done, it'll be necessary to overcome a Republican filibuster in the Senate. Even if the Democrats have a slim margin, 50-50 plus the vice president, Republicans can filibuster any of these things, which makes it so unlikely for right now that they will adopt any kinds of reforms that I've been discussing. But I do think it's possible. I think there is a path forward to make American democracy much more of a reality than just an illusion. Yury, I know I covered a lot in a short time, but I wanted to leave as much time for questions as I possibly could. So people can ask me anything about the law school, about this democracy project.
Great, thank you, Dean. So we have a number of questions that folks have put into the chat. Why don't we first cover some of the questions regarding the talk you just gave on the future of democracy? First question is, what is the realistic chance of getting rid of the Electoral College? And I think you touched on that in your talk.
I think it's zero, because the states that benefit from the Electoral College will never vote to eliminate it. And if they don't, you can't get to 3/4. Now, are there lesser steps that might work? As an example, if we didn't have winner take all, there would be much less likelihood that the loser in election would become president. Except for Maine and Nebraska, every other state allocates electors on a winner take all basis. If you voted for Donald Trump in California in November, your vote counted for zero. If you voted for Joe Biden in Texas, your vote counted for zero. But if we split proportionately, electors being allocated in that way, then everyone's vote would matter. I've seen statistical analysis that this would make it less likely that the candidate who lost the election would end up as president. The problem, though, is a collective action problem. No state wants to go first. California doesn't want to say, oh, we'll split our electors based on Democrats and Republicans who gets that percent vote. But unless Texas does it, California only injures itself by doing that. There is a proposal for a national popular vote compact where states would sign a compact where they pledge their electors to whoever won the electoral vote. The problem is, well, in part the problem is no red states have passed it, and I don't think they're likely to. But the larger problem is, even if they did, it's unenforceable. Let's say that a state like Texas says, we'll pledge our electoral votes to the candidate who wins the popular vote in Texas. And lo and behold, you have a situation where, say, Donald Trump wins the popular vote in Texas. The Texas says, we'll pledge our popular vote to whoever wins the popular. We will pledge our electoral votes to whoever wins the popular vote in the United States. Imagine that Donald Trump won the popular vote in Texas, but Joe Biden won the popular vote across the country. Under the National Popular Vote Compact, Texas would be obligated as electoral votes to Joe Biden. But what if it says, no, we're not going to do that? There's no way to enforce it. So I really worry about what is the solution to the Electoral College. And for reasons I explained, I think it's become much more likely that we're going to continue to have elections where the winner of the popular vote loses in the Electoral College.
Great. Next question. Should President Biden support increasing the number of Supreme Court justices, and any chance he will do so?
I think he should do so. I don't think he will do so. And I think even if he did, I don't think it will happen. Why increase the number of justices? After all, the number of justices is not set by the Constitution. It's set by federal statute. It's varied between 5 and 10 over the course of American history. 9 is a historic accident. When the country began, there were 5 justices. The country was divided into 5 regions. As the country grew, every time another area of states was added, another justice was added until it got up to 10. In the late 1860s, Andrew Johnson was a terribly unpopular president. He'd been impeached. Congress didn't want him filling a seat on the Supreme Court. So Congress said, the next time there's a seat on the court, we're just going to abolish it. And they did. And 9 has been the number ever since. There's nothing magical about 9. I would favor increasing the number of justices to restore ideological balance. Remember the statistic I mentioned. Since 1960, there have been 32 years of Republican presidents and 28 years of Democratic presidents. The Republicans have appointed 15 justices and Democrats only 8. I think what the Republicans did in blocking Merrick Garland from a hearing and rushing through Amy Coney Barrett shows why balance needs to be restored to the Supreme Court. President Biden has created a commission to advise him on this. It's an eminent commission. Berkeley law professor Bertrand Ross is one of the members of the commission. But I don't think there's any chance this can happen, because to increase the size of the Supreme Court would take a federal statute, and Republicans in the Senate will filibuster it. And I don't think the Democrats have the vote to be able to overcome a filibuster.
Next question, Dean. Do you anticipate Justice Breyer will step down?
I sure hope so. In March of 2014, I wrote an op-ed in the LA Times urging Justice Ginsburg to retire at the end of the term. I said, it looks like the Republicans are going to take the Senate in 2014. And no one knows what's going to happen in 2016. That was sure an understatement. And I said, if Ginsburg wants somebody with her values and views to take her place, she should step down this summer. There's a Democratic president, Democratic Senate. Well, I said the same thing relative to Justice Breyer. I worry that with a 50-50 Senate and the vice president picking the tie, all it takes is one Democratic senator, say, dying, and replaced by a Republican governor, and the Republicans then will have 51 votes, and the Democrats aren't going to get anybody confirmed at all. So I would hope that Breyer would retire sooner rather than later, and let President Biden then quickly pick a successor.
Next question is, what would it take to call a convention to write a new constitution from scratch? Assuming that's something that's desirable.
I really want to think about that a lot in writing this book. What I talked about today are flaws in the Constitution that trace back to its founding. In fact, I've tentatively titled the book I'm going to write, Bad Bones, to say that the Constitution in many ways was a deeply flawed document. It's what creates the Electoral College. It's what creates the Senate. It's what creates the court with so little accountability. But most of all, it was a document that institutionalized slavery. Now, there's a mechanism under the Constitution for calling a constitutional convention. It takes 2/3 of the states calling for a constitutional convention. Then Congress has to create one. And anything passed by 3/4 of the states then replaces the Constitution or amends it. It could be used for a new constitution. But of course, there could be new procedures created. Prior to the Constitution, as everyone knows, there was the Articles of Confederation. There was a clause in it that said any change in it had to be unanimous by all the states. To get around that, there was a constitutional convention created. And Article 7 says that so long as 3/4 of the states ratify it, it will be accepted as the Constitution. How is that legitimate? So I want to think more about how might we think about, and when is the right time to think about a new Constitution?
All right. Next question is, uh, Britain had a plebiscite to exit the EU. Is there any way to have a national plebiscite to address any of these reforms you discussed?
Our Constitution does not provide for a plebiscite or an initiative process. That, though, doesn't mean that Congress couldn't create one. Congress could create I guess it would be a non-binding vote, but a vote to advise it on an important question. And I don't have anything that would keep Congress from putting out the issue for the plebiscite and then the votes being counted. Congress certainly could do it if it wanted to.
All right, next question is, what significant legislative and regulatory steps can and should be taken consistent with the First Amendment to regulate misinformation, foreign and domestic, in the media and online, including reinstating the fairness doctrine? The prevalence of misinformation seems to accelerate much of the breakdown of democracy we are seeing.
I think it's a great question. The internet is the most powerful tool for speech since the invention of the printing press. It tremendously democratizes the ability to reach a mass audience. It used to be to reach a large number of people, you had to be rich enough to own a newspaper, get a broadcast license. Now anybody with a cell phone or even access to a modem can reach a huge audience. The internet gives to all of us immediate access to unlimited information. I'm sure all of us have been part of a dinner conversation where there was a factual dispute and somebody just reaches and takes out a phone and resolves the dispute. In my family, usually the disputes are about baseball or basketball and statistics. But the internet and social media also have a downside. Because it is so easy to reach a mass audience, then false speech can be circulated. The premise of the First Amendment is the best remedy for false speech is true speech. But why believe that the true speech will be heard in the same way? Why believe that the true speech will win out? Why, when there's so much misinformation, believe that the marketplace of ideas can possibly work? The Supreme Court has had mixed record in terms of the First Amendment and false information. In some instances, false information can be punished. Lying under oath in court, perjury can be punished. False and deceptive advertising is not protected by the First Amendment. It can be punished. But there's also times when the Supreme Court has said false speech is protected by the First Amendment. Consider a case from less than a decade ago, United States versus Alvarez. It involved a federal law, the Stolen Valor Act, that made it a federal crime for a person to falsely claim to have received a military honor or decoration. An individual falsely claimed to have won the Congressional Medal of Honor. He was prosecuted under this law. He argued that it was unconstitutional, and the Supreme Court ruled in Alvarez's favor. The Supreme Court said false speech is generally protected by the First Amendment. In the area of defamation, there's certainly instances where there can be defamation liability for false speech. But if you're talking about false speech of someone in government, someone who holds position, somebody who's running for government office, then false speech is generally protected. This New York Times versus Sullivan in 1964. Justice Brennan said, in order for free speech to survive, it has to have the breathing space that comes with protecting false speech. So I think that we can't generalize about false speech. Sometimes the court's allowed to be regulated, sometimes not. I think it would be particularly difficult in the political context. But smaller steps can be taken. I think it's important to prohibit so-called deep fakes with regard to political ads or in other contexts. A deep fake is where a computer creates an image that's false relative to reality, but it looks like you're watching the real thing. If there could be a deep fake of, say, Barack Obama endorsing Donald Trump the night before the election. California has outlawed deep fakes in that context, and also with regard to sexual material. And I think that's something that can be done. In terms of the fairness doctrine, I don't think the fairness doctrine was very successful. I don't think the court would allow the fairness doctrine today. But I would impose more liability in certain areas and more restrictions on social media companies. If a social media company has knowledge that speech on it is incitement, true threat, obscenity, child pornography, then it could be held liable for not taking it down under my proposal. I would want to prohibit social media companies from discriminating on the basis of the viewpoint expressed and try to make the social media companies less of an omnibus platform for any speech and more of a platform for speech that we can believe in.
Well, Dean, in the interest of being fair and balanced, let's turn to some of the questions about the law school. And if we have time, turn back to questions about your talk. First, do you anticipate in-person classes in the fall? And what about the alumni reunion in October?
Yes to both. Yes, we anticipate in-person classes in the fall. I have repeatedly told the students and the faculty that we expect to be fully in person in the fall. We are working out policy with regard to that, a remote option for faculty or students who, because of a medical condition, can't come in person. But overall, we plan to be in person in the fall. And yes, we plan to have reunion in person in the fall, though also a substantial online component for those who can't make it here. And this year's reunion is the 0, 1, 5, and 6 classes. Usually it's 2 classes are the reunion classes. And for this year, it would be the 1 classes and the 6 classes. But because we didn't do a live reunion last year, we're inviting the 0 and the 5 classes too. In fact, you're all invited to come to reunion. Would love to see you, even if this isn't your year.
Well, it so happens it's my reunion year, actually, Dean. So
good.
I'll be there and welcome the 0 classes and all of the others. So great. What do you think will happen with the state bar exam? Also, the current move to allowing individuals to practice law without passing the bar exam?
I think the California Supreme Court lowering the cut score by 3 points for the summer, October 2020 bar has really decreased the pressure on the California Supreme Court. The bar pass rates went up dramatically by virtue of making the cut score more favorable. Berkeley had a 96% pass rate when our JD students were taking the bar for the first time. It's the highest probably that it's been ever, if not just in many years. I don't see there is a chance in the world that California is going to create diploma privilege. I think that the bar exam is here to stay in California. The students last summer pushed so hard for diploma privilege. And I said in California, especially because the large number of unaccredited or state accredited law schools, I didn't see the California Supreme Court creating diploma privilege, and I didn't see them being willing to differentiate among law schools. I think there might be further adjustments to the cut score. I think there might be changes in the way the bar exam is administered in the future, but I don't see a fundamental change in having a bar exam.
All right. Next question. Does Berkeley still have a Federalist Society? The white men who come out of that organization are the judges who holding up these changes. So why is that organization still allowed to exist at our school?
Yes, we do have a Federalist Society chapter. And I'm committed that we should have a Federalist Society chapter. Why? Because a law school should be a place where all ideas and views can be expressed. If I were to outlaw the Federalist Society from participating in the law school, assuming I could for a moment, then when there's someday going to be a very conservative dean, they're going to outlaw the ACLU and the American Constitution Society from being there. I always tell my students, the only way that our speech will be protected tomorrow is to safeguard the speech we don't like today. But all of this is much too complicated. The simple rule is we couldn't outlaw a Federalist Society chapter if we wanted to at Berkeley Law School. That would violate the First Amendment and freedom of association, but I wouldn't eliminate the Federalist Society.
All right, back to some questions. I think we have time for a couple more questions. questions on your talk about the future of democracy. So it appears to me that the power of the executive branch in the modern era is far broader than what the framers intended. Is that accurate? And if so, should the power of the executive branch be more limited?
Yes, and yes. Yes, there's no doubt that the powers of the executive branch are much greater than were anticipated in 1787, but so are the powers of Congress much greater than anticipated, and so was the power of the Supreme Court. The Constitution was written in 1787 for a small agrarian society of 13 states. And the powers of all of the branches of the federal government have grown tremendously as the country has grown. I believe in checks and balances. I believe for any major government action, the goal should be to have two branches of government involved. I think that's what the framers wanted in checks and balances. So to adopt a law takes Congress being involved and the president being involved. To enforce a law takes the president being involved and the courts being involved. To appoint a judge or an ambassador takes the president involved and the Senate involved. And I worry that in many areas we've given executive power without the checks and balances. And I'd want to restore checks and balances. I really do think it's possible and necessary to limit executive power. Both Democratic and Republican presidents have increased presidential power, doing more and more things by executive order rather than by statutes. And though I agree with some that's been done, disagree with others, I think it's the wrong strategy.
All right, next question is, while this didn't happen in 2016 and 2020, I worry about the possibility that a majority of voters will vote in an incompetent and or anti-democratic president like Trump, who then vigorously undermines democracy and suppresses the opposition and dissent. This seems to have happened many times throughout history and still does. As we've learned, many of the guardrails against this were merely norms. What can be done about this?
Well, in terms of the path forward, I think there's much that Congress can do to protect the right to vote. And a bill has passed the House that would require that states allow absentee ballots, that would have independent commissions do districting for House of Representatives, that would reinstate the Voting Rights Act, which was declared unconstitutional by the Supreme Court, key provision in 2013. So I think passing a voter protection bill in Congress, a pro-democracy bill in Congress, is really crucial in this regard. Beyond that, I share your fear. Remember the statistic that I mentioned. We were only about 49,000 votes from Donald Trump being elected president, despite losing by 7 million votes.
In your opinion, who is to blame for the current divided Congress, which can hardly agree on anything, and what's the way out?
Everyone is to blame. I think it reflects our deeply divided society. If you look at how deeply polarized the American society is, it shouldn't surprise us that a Senate is also that way. There's lots of blame to go around. Always try to be candid about my views. One of the things that I hope Donald Trump is most criticized for in history was the way that he politicized a pandemic. There are times, moments of crisis, when there's an opportunity for real national unity. Think about how after 9/11, George W. Bush's approval ratings were over 90%. We came together as a country. What if in March of 2020, Donald Trump had said, COVID is a communicable disease, it's an enormous threat. We have to follow the science. We're going to need to shut down businesses in order to make sure we don't spread this disease. People are going to need to wear their masks. This is our time to come together as a country. He would have been reelected as president in November of 2020. And I think it would have been unifying in a way that would help heal the divisions in Congress and in society. But Trump did just the opposite. He politicized a communicable disease in a way that we see to this moment. saw a statistic, 30% of Republicans say they won't get vaccinated. And only an infinitesimal small part of Democrats won't get vaccinated. So the divisions in the Senate aren't just about Trump, but he had a chance to heal, and he did just the reverse.
Okay, one of the last questions we have time for. Is there any basis for a constitutional challenge to the restrictive voting laws being enacted now in some states?
Yes. Let me back up something I alluded to. Prior to 2013, Section 5 of the Voting Rights Act would require that states like Georgia get pre-approval for changing their election systems. The Supreme Court in Shelby County versus Holder, June 25th, 2013, struck down those provisions of the Voting Rights Act. But there's still Section 2 of the Voting Rights Act that says that state and local governments can't have election systems with a racially discriminatory effect. Federal United States Court of Appeals to the Ninth Circuit, an opinion by Judge William Fletcher, en banc opinion, found that a recent Arizona law violated Section 2 of the Voting Rights Act. The case was heard in the Supreme Court a couple of months ago. I'm worried about what the Supreme Court's going to do, but if Section 2 survives, it can be used to challenge those laws, and some of them can be challenged for violating equal protection.
Great, Dean Chemerinsky. One last comment from one of our audience members, Judge Filer. He said, Erwin, we need you on the Supreme Court. Great presentation. And as a follow-up question to that from another audience member, if President Biden packs the court, will you accept the nomination?
I have the world's best job being Dean of Berkeley Law, and I'm committed to staying. Also, I'm about to turn 68, and I don't think Joe Biden should pick a 68-year-old for the Supreme Court. You know, Amy Coney Barrett was 48, Neil Gorsuch was 48, Elena Kagan was 50, Clarence Thomas was 43. It's in that age range that Biden should pick. But I do feel so incredibly fortunate to be at Berkeley Law. There really is no other job like it in the country. And I thank all of you for coming tonight and for all of your support for the law school. Your support just makes an enormous difference.
Well, Dean, we hope you can stick around the law school for many, many more years. I think everyone in the audience and all of the alumni community that we hear from are very appreciative and just so thankful to have you as the Dean of the Law School. And I want to thank you very much for that very enlightening and thoughtful talk and Q&A. I want to thank everyone here in the audience for attending. I'd encourage all of you to look out for our future alumni events, watch your emails for information about those. And everyone take care and stay healthy.